For session 1, we have amongst us Dr. Sandeepa Bhatt, Professor of Law, Director of Center for Aviation and Space Law, National University of Juridical Sciences, Kolkata. Dr. Bhatt has experience of researching on 5 major research projects sponsored by World Bank, ISRO, West Bengal Judicial Academy, Ministry of Justice and Ministry of Environment, Forest and Climate Change. Apart from being member of Board of Advisors of Global Network Against Weapons and Nuclear Power in Space, United States, he has the distinction of being the member of American Society of International Law, US, International Academy of Space Law, Moscow, Russia, and International Institute of Space Law, Paris, France. Dr. Bhatt has published 3 books on space law and 3 books on medical law. In addition, he has published more than 50 articles in journals of international and national repute. He has presented over 110 research papers in international and national conferences. Sir also has distinction of being a member of Indian Space Research Organization Expert Advisory Group for drafting the National Space Act, India. We welcome you, sir. Over to you.
Yeah, thank you so much. Thank you for that introduction. Very good morning to all of you. And whenever actually I speak in CMR, I always find as if actually I'm in my home university. I should always be thankful to Professor Subramania for his kind invitation for these programs. Yes, from last almost 2 decades, I'm into this teaching profession. But I started teaching international trade law a little late. Let me just acknowledge that. Since last almost 12 years, a little more than 12 years, maybe the 13th year, I'm teaching international trade law. So whatever I'm going to put forward here is more in terms of my own personal experience in the last little over 12 years in terms of international trade law. Even though actually my experience of space law and other subjects is much more than that. I welcome any difference of opinion. I don't have any problem in terms of it. Plus also actually any observation or any contradiction with respect to the methods which I'm basically trying to put forward regarding teaching of the international trade law. Now to start with, I would like to say that teaching international trade law is something entirely different from other subjects. It's a different ball game. It's more challenging. And why it is more challenging? I should say because of 2 reasons. I always tell my students that international trade law is more of economics and politics rather than the law itself. It's all actually the negotiations. It's all actually political and economic considerations which have resulted in what is called as WTO law or the international trade law. And we as the lawyers or we as the people having the legal background find a lot of difficulty in comprehending the economics and politics behind the international trade law. We are not in a position to comprehend it properly. Of course, in the say 5 years LLB program, we should have studied economics or political science, but all of us know we study it as a kind of a charity. First 2 years, non-law subjects actually we all study. It's mandatory for us, we will study. And then we will jump on to the law subjects without having any interconnection between law and the social science subjects. That is why comprehending the economics and politics behind the international trade law becomes very, very difficult. This is one of the reasons why it is more challenging. And the second reason is the volume of WTO agreements, or how much of development which has taken place in the international trade law. If you look into it, it is unimaginable. The mere agreement, the Marrakesh agreement, which has established the WTO, right, and also all the covered agreements under the WTO. If you look into that, it is a document of 27,000 pages. You don't find any other treaty having 27,000 pages. One can imagine how lengthy is the bare provision itself, and plus how lengthy would be the interpretation of each of these provisions. There are at least few thousand cases decided by the WTO panel appellate body as well as the GATT panel. And if you look into the off late cases, they're all running into say 800,000 pages. Each case running into 800 to 1,000 pages. So that kind of actually the development has taken place at the dispute settlement level. And that is not the end of it. Apart from the cases which are decided at the international level, we have at least a few lakhs of cases on the international trade decided at the domestic level. Yes, at the domestic level. Many of us might not be aware of the fact that international trade law questions are settled also at the domestic courts level. It is true because at the WTO level, only those cases which have been brought by the states are going to be decided. It's only the states who can take the matters to the WTO, dispute settlement mechanism. But whereas individual trade disputes are concerned, suppose if a foreign trader has got any grievance against actually the Indian tariff system or the customs authorities collecting the customs duty at the port or maybe airport, wherever it may be. If there is any individual grievance, that has to be settled in the ordinary courts of law, in the domestic level. So every country has got its own mechanism for settling these individual trade disputes at the domestic level. And there are a few lakhs of cases which have been decided together across the globe. So this is the volume of international trade law. Impossible to actually cover it in one semester. And of course, by virtue of this, you can find that in some of the universities abroad, you have specialization in international trade law itself, LLM in international trade law, wherein they would be studying at least 8 subjects just in the WTO law. 8 separate subjects. Right? Fundamentals of GATT, dispute settlement, GATS, TRIPS, like that, separate subjects. There are 8 subjects which are actually almost taught or studied in one course. So therefore, first we have to understand that it is almost impossible for anyone to cover the entire WTO law or the international trade law in any course. So these are the 2 reasons why teaching international trade law becomes more challenging when compared to that of actually other subjects. Added to this, I should also tell you a couple of other things. Apart from the WTO law, we also have got the deviation of international trade law through the regional agreements. The WTO itself permits the regional agreements, bilateral or plurilateral agreements actually. Of course, the initial understanding was that once the bilateral plurilateral agreements take place, once the smaller unions take place, there would be integration between the smaller unions to form a bigger union. That's how the multilateralism would be established in the course of time. So it was thought to be a kind of a stepping stone for multilateralism. That's how it was actually basically thought of. But unfortunately, all these agreements remained at the bilateral or plurilateral level. Multilateralism did not happen in an effective way. So, in these bilateral or plurilateral agreements, states have agreed for more commitments, more liberalization of trade. For example, European Union, NAFTA, SAFTA, Mercosur, different kind of actually the free trade agreements or maybe the regional trading arrangements, they have all given more favorable treatment with respect to international trade. So if we want to study them as well, we can imagine how voluminous is the international trade law. On the one hand, the WTO regime itself is very complex and very detailed. There might also be so much of deviation under the regional agreements, which have mushroomed like anything at present. In one of my previous presentations in CMR itself, I discussed in detail about how exactly the mushrooming of the bilateral or plurilateral agreements have become a kind of a problem. So that's again an issue in terms of teaching international trade law. Then, if we look into our own curriculum, especially in India, maybe at the LLB level or maybe even at the post-graduation level to a greater extent, our curriculum is heavily domestic law oriented. It's not international law oriented, except in those universities wherein LLM in international law is provided as a specialization. Except them, in every other places, we can find that our both graduation as well as post-graduation curriculum is more or less domestic law oriented. So, majority of the people who have been asked to teach international trade law, they themselves might not have studied international trade law. In many universities, what happens is that whatever subject is not basically being taken up by other faculty members would always be imposed on the newcomer. International trade law in many of the cases would be in that basket, wherein it would be imposed on a newcomer. And many of these newcomers might not even have actually the background of international trade law, and they have to adopt themselves, or they have to become a kind of a makeshift teachers for the purpose of teaching international trade law. So this adds on to the problems in terms of teaching international trade law. Apart from these issues or the problems, I would also like to tell that teaching international trade law also requires a proper orientation to the students. Because the current trend is very clear. Students want to study any subject only if that subject has got some practical significance. Only if there is any practical significance. They're important. I mean, their first question is that how can they develop a career out of maybe a particular subject like international trade law? And since international trade law, you don't find it on day-to-day affairs, unlike maybe CPC, CRPC, which actually is practiced every day in the code, or maybe the tort law or contract law, which they can see on day-to-day basis. They can't see the application of international trade law at, at the stage when they are actually studying it. So as a teacher, I believe we have to first make them understand the fact that international trade law opens up a lot of opportunities for them, not just in the domestic level, but also at the global level. So this proper orientation, I believe, is something which basically keeps them motivated to study the international trade law, and also maybe throughout the semester, they would be having interest in the subject by virtue of it. Of course, I'm not telling this has to be done only for international trade law. This has to be done for every other subject. But in most other cases, it may be easier since you would be able to connect it to the happening in the surroundings, right? So it is possible for you to easily actually show it, like say constitution law. So many actually things are in the news. You can connect it to the classroom discussion, and you can actually just impress upon the students how exactly actually constitution law is in practice. It becomes easier. But international trade law, slightly trickier. We need to be actually sure enough with respect to telling to the students how can they build their career, and then accordingly we have to provide a proper orientation to the student so that they can actually have interest in the subject throughout the semester. Now, how can we do this? I should always say research. You have to start with the research. Yesterday, actually, I was speaking on this research and teaching in one of another FTP. To my understanding, unless and until we research on a particular subject or a particular area, we will not be able to have a grip over it. And when I say research, It need not be for a PhD or for a funded project. We always have that, say, misconception that research is nothing but actually doing PhD or LLM dissertation, funded project, so on and so forth. No, there is also scope for research with respect to actually training us for teaching. And when I say research, I'm not telling you about actually studying or by hearting particular literature or maybe preparing for the classes for the purpose of ensuring that I can deliver it for 1 hour without any kind of a break. No, I mean, of course, that is important. Efforts are required in terms of actually preparing for the class and delivering the lecture. And what I'm trying to tell you here is to go a little ahead to conduct research in any area which we are teaching. And international trade law requires a lot of research for the purpose of comprehending the practical application of international trade law. Just actually the decisions of the courts or maybe the dispute settlement body would not make us to understand how the international trade law is operating in practical sense. We need something from the field. We need something out of our research. And this research may be, I mean, even if it is not for a PhD, not for a project, not for a publication, we can do that independently to facilitate our teaching. Let me tell you that I did this because actually international trade law is a hard nut to crack. It's not that easy to deliver to the students. I did this whenever I had a problem in actually the certain areas in terms of my understanding and delivering. I started thinking in terms of actually developing a kind of a questionnaire. And this has to be very simple enough. The questionnaire should not be complicated because we are asking some experts to give you the feedback. They would definitely be not having much time for the purpose of giving the feedback, right? And also more importantly, nobody wants to spare time for others. So that's actually the common factor. But still, there is no harm in making an attempt. I have tried it in many of the areas wherever I have got the difficulties. A short questionnaire, maybe with say 7, 8 objective type questions, right? With simple answers, the multiple choice questions like that. Coupled with that, maybe 1 or 2 subjective type questions wherein they can give their feedback. So area specific, if we can do that, and if we can actually circulate it to some of the experts in trade law, definitely we will be able to get a better insight in terms of actually teaching that area, especially from the practical perspective. And we can find this in say anti-dumping, subsidies, different actually the kind of these agreements. We as a lawyer would not be able to understand the nuances, how exactly it goes. We would not be able to understand it properly. But when we get the feedback from some of actually the experts, not just in trade law, but generally in trade or commerce, we will be able to appreciate the other side of the argument. We'll be able to do that. So in many of these things, I mean, many of these actually areas, I have already experienced or I have already done this, and a couple of them I have also published this article subsequently, right? With the help of those feedbacks, whatever I have obtained from some of the experts, of course, I mean, Ministry of Commerce and Industry, maybe some people from there actually you can contact, or IIFT, Indian Institute of Foreign Trade. Of course, since I am actually a faculty member also of IIFT here in Kolkata, it has become easier for me to get access. But of course, you can also establish the link with the different such kind of institutions, and anyone who's teaching international trade law can also conduct independent research for the purpose of supplementing teaching. I should say that this independent research helps a lot in terms of clearing our fundamentals. If I have to put it simple, in teaching international trade law, we have to be clear about fundamentals. When I say fundamentals, let me tell you what is there within the ambit of it. 5 principles. 5 principles which are there under the GATT as well as reflected in almost all the covered agreements of WTO. Foundational principles like MFN treatment, tariff binding, national treatment, prohibition on quantitative restrictions or the quotas, and finally the transparency in the trade measures. So these 5 fundamental principles, which originated in the GATT, also continued in almost all WTO agreements, whatever covered agreements which we are speaking of, all of them reflect one or other fundamental principle in their own way. So we have to be clear about these 5 principles first. Then, what are the exceptions to these principles? Of course, there are certain exceptions which are actually mentioned within the provision itself, like Article 1, Article 1.2, MFN treatment. Actually, Article 1.2 has provisions within the MFN. Article 3, national treatment, also has the exceptions from Article 3.7, and also like that, there are exceptions which are mentioned within the provision. But apart from that, there are also general and security exceptions. General exceptions and security exceptions. Under the GATT, Article 20 of the GATT showcases 10 different general exceptions which are applicable to all the GATT obligations. Article 21 speaks about security exceptions, certain kind of measures which are justifiable in a circumstance wherein actually the essential security interest of the state is at threat. So that's how we have to actually understand the fundamental principles in light of the exceptions for the purpose of actually better appreciating them and to make the students understand about them. Another important thing which we need to comprehend out of our research is the procedural aspects. Of course, most of us are weak in this. Most of us are weak in this because actually the procedural aspect is more in terms of administrative actions rather than the legal actions. And when I say procedural aspects, I'm telling primarily about the process of investigation. WTO agreements have got the agreements with respect to subsidies, anti-dumping, safeguards, so on and so forth. All of them speak about an investigation and the procedures are laid down for the purpose of investigation. We are always weak in this and we have to do the research. In fact, to be very precise, my major, actually the research which I have carried on over the period of time has been fundamentally on the procedural aspects. Getting the feedback from those who undertake the investigation, safeguards investigation, subsidies investigation, anti-dumping investigation, etc. Getting their feedback for the purpose of understanding how exactly the procedures are implemented in finding out the different aspects. So we have to actually understand the procedural aspect, and we should also include within the procedural aspect the dispute settlement mechanism. The dispute settlement mechanism. Of course, you have a detailed code in the form of dispute settlement understanding. It lays down different procedures, what has to be done at the different stages. All those things are mentioned therein. But unfortunately, there are certain things which are not mentioned in the dispute settlement understanding. And they're also equally important. There are some of equally important aspects which are not being dealt explicitly under the dispute settlement understanding. For better appreciating them, we definitely need to undertake the research. So I should say that for teaching international trade law, we should definitely undertake a serious research, which need not be for a PhD, need not be for a funded project, need not also be for publication of an article. Of course, out of the research, there is every possibility of publishing an article, and all of us are aware of the fact that how significant it is now to publish an article, that too maybe in the care listed journal or maybe Scopus, whatever it may be. So research, I should always say that is the starting point in the international trade law teaching. Now, what is to be taught? There are a lot of things, as I've already pointed out. I have also seen the syllabus of international trade law covering so many things, and WTO law being one part of it. Covering mercantile law, say shipment laws, ancestral laws, different laws are covered within the ambit of one subject, international trade law, and WTO being one part of it. Of course, to be very precise, when I studied international trade law also in University of Mysore, the same syllabus was there. WTO was one portion of it, actually. I should say it makes no sense. Because the WTO agreement itself, I have already told you how voluminous it is. And universities overseas are actually dividing that into 7-8 subjects, 7-8 separate actually the subjects to be taught in a year. If we still go with actually clubbing all of them together in one subject like international trade law, we will not be able to do any justice to the student. They will not be able to make any sense out of actually the course. So I recommend that we need to keep as minimum as possible with the focused discussions on those areas. And those areas, whatever interdisciplinary issues are arising, that should be discussed in the class. So to my understanding, we should keep it minimum with the focused discussions. In light of that, if I have to tell about my structure of syllabus, I have divided the course into 8 modules. 8 modules. I start with the module 1, evolution of the GATT WTO. How exactly barriers to the international trade came into existence. What are the reasons for the barriers? Why there was a thinking in terms of liberalization of international trade? Because the purpose of a GATT WTO is to go for the trade liberalization. What motivated such kind of liberalization? How GATT has come into existence, and then subsequently the WTO in 1995. How did these changes took place, right? How, I mean, the period between 1947 and 1994, GATT to the WTO agreement, how this period has been successful in terms of liberalization of the trade. These things provide the fundamentals of international trade law. We have to discuss that in the first module. 2 things which need to be made very clear to the students in this module is that first, everything goes by trade negotiations. In many cases, we might not find the WTO agreements as a sensible from the legal perspective. Students might always have this question. They might ask you how sensible it is. Legally, it doesn't make any sense. But if we make them clear in the beginning itself, it is entirely on the basis of trade negotiation. And as Rajbala, one of the great scholars of international trade law, says, it is nothing but a politico-commercial arrangement. Politico-commercial arrangement, politics and economics. That's how actually these negotiations and agreements have been entered into. So that we need to make it clear to the students so that they should not say at a later point of time that legally it is not making any sense. Second thing which we need to tell them is that most of the aspects of the trade are the part and parcel of the sovereignty of the state. Like fixation of the tariff, how much of tariff has to be collected or how much of internal taxes need to be levied. International trade law cannot say that, no, you should not levy any tariff, you should not levy any taxes. States themselves have to voluntarily say that this is the maximum limit beyond which we are not going to levy the tariff or the customs duty. So in other words, we should make them clear that the WTO law is just a limited compromise of the state sovereignty. It's just a limited compromise. It's not that actually the state would be completely doing away with its sovereign rights in terms of international trade, and they have to liberalize without any restriction. No, it's a limited compromise of sovereignty, and therefore everything operates on the basis of state willingness and cooperation. These two things we have to make it clear in the first module itself, and also actually while analyzing the journey from the GATT to the WTO. Module 2, I discuss in detail the 5 pillars of the GATT. The most favored nation treatment, Article 1. Tariff binding, Article 2, how exactly the tariff binding has to be adhered to. National treatment, Article 3. Then Article 11, speaking about prohibition on the quotas or the quantitative restrictions. And finally, the transparency requirement under Article 10. There is a lot of jurisprudence which has been developed. Multiple cases are there, and we need to pick only very significant cases which have made the jurisprudence. It has made the jurisprudence. So I usually pick around, say, almost actually 10 to 12 cases to discuss these 5 fundamental principles. Especially first, MFN treatment itself, actually there are many cases, because like product interpretation, we need to look into the jurisprudence in different cases. So those important cases has to be discussed here, and then subsequently exceptions to these principles also need to be discussed, especially which are there under the provision, and Article 20 and 21, how do they operate with respect to these fundamental principles. So usually I explain to them in the second module. Third module should be on the dispute settlement mechanism, because the entire WTO agreement or the provisions of the WTO agreement would not be of much use unless and until it is implemented practically. And this practical implementation requires a very, very strong dispute settlement mechanism. Of course, we have got one. So we have got the dispute settlement understanding, and then subsequently the dispute settlement body has been established, appellate body, panel, all these things actually have been established for a structured dispute settlement mechanism. Unfortunately, these procedures are not free from problems. There are issues with respect to that. And if you look into the current scenario, the WTO appellate body has become dysfunctional, especially United States has got multiple objections to the WTO dispute settlement mechanism. Therefore, it has been paralyzed at present. And we have to not just make the student understand about the procedure to be followed in terms of the dispute settlement, but also we should ensure that they understand the current concerns in the WTO dispute settlement mechanism. So in the third module, once we clarify the fundamental principles in the first 2 modules, historical background and fundamental principles, we should make them to understand about what is the dispute settlement mechanism, how does it operate, and what are the current concerns. Then the 4th module, I devote it on GATS, G-A-T-S, General Agreement on Trading Services. This is significant because if you look into the WTO agreements, we have the GATT 1947 as amended by 1994. Then 6 understandings which amend the GATT. Plus there are 14 other multilateral trade agreements. 14 other multilateral trade agreements which are part of actually the WTO agreement. Out of the 14, only 2 are the standalone agreements. They are GATS and TRIPS, GATS and TRIPS. These are the standalone agreements, and remaining 12 are the agreements supplemental to GATT itself, like anti-dumping, subsidies and countervailing measures, technical barriers to the trade, sanitary phytosanitary measures. All these agreements are supplemental to one or other provisions of the GATT. So GATS is a standalone agreement having the provisions slightly different from GATT. The fundamental principles are there even under the GATS. MFN is there, transparency is there, national treatment is there. All these fundamental principles you can find therein. However, we can find that there is a drastic difference in their application under the GATS and GATT. This difference, we can find it in two levels. One level, structurally there is difference. Under GATT, all the fundamental principles, right? GATT, which is applicable to the goods, trade in goods, all fundamental principles are general obligations of the states. That means once a state becomes a party to the GATT, it has to follow all the fundamental principles. But on the contrary, under GATS, there are two parts. One is the general obligation, wherein we can find MFN treatment, transparency obligations, we can find it under the general obligation. So MFN and transparency are mandatory for every state party of the GATS. But on the contrary, national treatment and market access, like say prohibition on quotas or other things actually, national treatment and market access are made as part of specific commitments under Part 3. Specific commitments in the sense, unless and until the state makes a separate commitment, they are not applicable. So that is why we have to make them understand that the interpretation of the GATT is different from GATS. Structurally, GATT makes all of them as binding obligations. GATS differentiates between something binding and something as voluntary to be taken up. That is one thing. Second thing is that even in terms of provisions, there are market differences. Some of the provisions have been strengthened under the GATS, like the transparency requirement. There is a stronger provision under the GATS. But some of the provisions, we find more problems in terms of interpreting. There are concerns in terms of the interpretation of actually some of these the provisions. Maybe the example is MFN treatment, or even actually to a certain extent market access and national treatment. We can find more problems in terms of interpretation. So that's why we have to make them understand clearly that the interpretation of the GATT and GATS differ. Fifth module, of course, I should say that the fifth, the sixth, and seventh module, these three modules, I focus primarily on three of the trade remedy actions, three important trade remedy actions. Right. So three important trade remedy actions. Trade remedy in the sense, whenever actually because of certain reasons, more and more importation of actually particular product happens, and the damage is caused to the domestic industry. By virtue of them, damage is caused to the domestic industry. Then the concerned state would go for protective measures, some kind of a protective measures. They will levy some kind of a duties or try to restrict the trade, so on and so forth. So these are basically called as trade remedy actions. And under the GATT WTO regime, we can find three of them as the most significant ones. Agreement on anti-dumping, which is supplemental to Article 6 of the GATT. Then agreement on subsidies and countervailing measures, again supplemental to second part of Article 6, because the GATT Article 6 speaks about both anti-dumping duties and countervailing duties. And they are separate. They're separate, they're not same. So two separate agreements are there for the purpose of supplementing anti-dumping and countervailing measures. So Module 5, I take anti-dumping. Module 6, I take subsidies and countervailing measures. And in fact, what is the difference in the process of investigation in both the cases? Right? I told you that the procedural aspects are also equally important, because investigation has to be carried on in all these cases. Whenever actually the trade remedy action is supposed to be invoked by a state, the state has to carry on an investigation and they have to prove certain factors. They have to prove certain factors, right? But there is a difference in terms of investigation under both anti-dumping and subsidies and countervailing measures agreement. How exactly there is a difference? What procedures need to be followed in anti-dumping? What should be in the case of SEM? That has to be made understood to them. Then the seventh module, which is on safeguards, another trade remedy action. That is an extension of Article 19 of the GATT, an emergency measure. Interestingly, safeguard actions are supposed to be taken in a circumstance wherein there is no illegal trade or there is no unfair advantage given to the foreign trader, right? So safeguard actions are taken when the foreign trader is involved in the fair trade. Anti-dumping and subsidies is different, because in anti-dumping, the foreign trader is involved in an illegal activity or unfair trade practice. He's dumping a product into a territory, and the state is basically taking a protective measure to counteract the dumping. Subsidies and countervailing measures, therein also a foreign country has given a subsidy. It has given a kind of a benefit to its actually the producer for whatever reason it may be. And that benefit foreign trader is enjoying, and he's trying to distort the competition in your market. Therefore, there is better justification for countervailing measures. Anti-dumping and countervailing measures, one might have better justification. But on the contrary, when it comes to the safeguard measures, there is no such kind of unfair trade practice. There is no such kind of undue advantage given to the foreign traders. They are trading fairly. But despite that, our domestic industry is injured because of the reason that maybe our domestic industry is not competent enough like the foreign trader. Right? So safeguards basically speaks about an emergency action which can be taken by the state only when the injury to the domestic industry is very, very serious. And there is a serious injury to the domestic industry, right? Because at the end of the day, state has to ensure that their domestic industry would not vanish. Domestic industries are the backbone of economy. So if domestic industries are actually vanishing, that means the economic disturbance would be there, or the turmoil would be there in the country. That is why safeguard action is something different from anti-dumping or SEM actions, subsidies and countervailing measures action. So we have to make this clear to the students, and then we have to also make this clear to the student that the process of investigation and the ultimate outcome in all these three are different. Finally, the last module which I teach is on the trade and environment. Trade and environment. There is a popular saying that international trade law or promotion of more and more trade is a disaster from the environmental and labor rights perspective. Promotion of trade is a disaster from the environmental or labor right perspective, because capital would always go in search of the cheap labor and very cheap technology. At the end of the day, they want the cost of the production less so that they can be competitive in the market. So this has an impact on the labor standard as well as environmental standard. Cheap technology, which might be actually polluting more, so it would be causing an impact on the environment. It is very important to study the interrelationship between the trade and the environment because of two reasons. One, that the interdisciplinary approach, as I told you, we cannot actually look the trade in isolation. We have to make the student understand about the fact that there are also other regimes which we need to respect in the process of trade liberalization. WTO law should not be looked in isolation. That is the first thing which is clarified out of the module on trade and environment. Second, and the most significant factor which is served out of this is that Article 20 of the GATT, which speaks about general exceptions, especially Article 20B and Article 20G. 20B is on actually a measure for the protection of human, animal, plant, life or health. And 20G is a measure relating to the conservation of exhaustible natural resources made effective in conjunction with similar sort of a restriction on the domestic level. State can do that. A measure necessary for protection of human, animal, plant, life or health, or a measure for protection of exhaustible natural resources can be taken by the state, even if it is trade restrictive in nature. When we make them to understand Article 20B and Article 20G, we will also be able to make them to understand how to interpret the entire Article 20. Because Article 20 exception, I don't know, I mean, how many of you are teaching actually the international trade law? If you are teaching it, you should be knowing about it. It has actually a complicated system. There is a chapeau, there is an opening part in Article 20, which has 3 requirements. They need to be complied with. Then there are 10 itemized exceptions. And out of the 10 itemized exceptions, at least one has to be complied with. At least one in its entirety. I'm saying in its entirety because each of these itemized exceptions have got multiple factors to prove. 3 factors of the chapeau plus the factors which are there within the ambit of itemized exception. Like say, for example, Article 20G. Article 20G, first of all, one need to prove that there is an exhaustible natural resource. Second, measure is relating to the conservation of exhaustible natural resources. Relating to has to be interpreted. Third, it has to be made effective in conjunction with similar sort of a restriction on the domestic production or consumption. That should also be a measure operating in the domestic level to prevent the exhaustion of those resources. So that has to be interpreted. So Article 20 interpretation is actually a kind of a tricky process. We have to interpret each part of Article 20 and test it, of course, itemize the exception and also test it under the chapeau to comply with the Article 20 requirements. So when we teach them the module on trade and environment, especially with the help of cases like the US tuna dolphin, US gasoline, US shrimp turtle, right? And then subsequently in terms of necessary EC asbestos, US gambling, so on and so forth. When we actually teach them with the help of these cases, they would be able to understand specifically how the exceptions under Article 20 operate, and then how exactly we have to interpret the fundamental principles in a limited way in light of the exceptions. That is why I feel that a module on the trade and environment is very significant in a course on international trade law. So these are the 8 modules which I usually teach actually, and I also feel that they should be the part of the core international trade law course. Now, last thing, what could suit in terms of teaching? Again, my personal experience, let me tell you, right? So you can contradict and you may have a different experience. What I do, I should say that I mix usually 4 major methods in terms of teaching process, or maybe in terms of learning process. Lecture method, definitely indispensable. We have to make them understand at least about the fundamental principles. So lecture method predominantly has to be adopted for the purpose of actually teaching international trade law, but it has to be supplemented with hypothetical examples. I always teach any principle or any provision with the help of a hypothetical scenario, connecting that to the real world situations. And it helps a lot. Even though provision is very, very difficult to comprehend, it helps the students a lot to understand that easily with the hypothetical example. So combining the lecture method with the hypothetical example, I usually actually go forward with actually teaching the fundamentals of international trade law. Then cases. I've already told you that there is a plethora of cases decided at the international level as well as the domestic level. Domestic level, we will not be able to touch. International level also, we have to select the cases. What I do is that, of course, there would be some cases which we will be referring while deciding actually or while discussing the jurisprudential development. But I picked 30 important cases which should be discussed in detail in the class. My syllabus has got 30 cases, right, which are discussed in the class. Almost every alternative day, I ask a student to make a case presentation, depending on the area which I'm covering, right? So depending on actually the coverage, almost every alternative day, or more or less actually it comes like that. Every alternative day, there would be a case presentation by the student. I give 10 minutes for the presentation, maximum 10 minutes. Within that, they have to wind up with actually the crux of the, just facts to be very brief. What was the decision? What did the panel hold? Did the appellate body agree with the panel? Or did it reverse it? So a case presentation for 10 minutes, which has to be supplemented by another maybe 15, 20 minutes of deliberation on it. 15 to 20 minutes, right? Whether the decision is correct, is there any other angle which is there, right? So all those kind of stuff should be discussed after the case presentation. However, this, as per my understanding, can be done effectively only when the students are mandatorily asked to read the relevant portion of the case. We can't expect the student to read a 800-page or 1,000-page judgment. That is not possible because so 30 pages actually 800 pages or 1,000-page judgment. Definitely, 30 cases actually they would not be able to do it. Rather, what I do is that I point them out what is the relevant issue in a particular case for the classroom discussion. And I ask them to come prepared for that. And this is actually a homework for everyone in the class, not just for the one who is presenting the case. And after that, deliberation on the correctness of decision makes a lot of sense because everyone has come prepared with their own actually the say idea about the judgment. They have understood the judgment in different way and they have their own idea, and the discussions in the classroom makes it very effective for the purpose of a kind of a participatory learning by the students. So that's the other method which I use. Finally, I mean, of course, in the national law schools, we do have the research projects for each the paper, but some of the traditional universities might not have, but still there is every possibility of experimentation. I provide the research project, and when I provide the research projects, I ensure that these projects are not on those areas which are within the syllabus. The 8 modules which I have basically pointed out, these projects are not on them. Of course, we have a separate system of evaluation. Almost 50 marks would be internal, another 50 would be external. Out of 50, 20 would be the project, and 20 would be the project presentation, and 10 would be the class participation. So that's why we have 50 marks on all these aspects only. That's why I give actually a topic outside the normal syllabus, which is structured here, to cover other areas of international trade law, and that too having the current practical significance. Like say, for example, Indian restriction on the Chinese apps. How exactly we can view it under the WTO regime, right? Then Russia-Ukraine conflict. So the trade restrictions which are emanating out of that, how can we view that? So like that, actually, the different topics on the cutting edge areas outside actually the syllabus which we are covering in the class, I allot it to the students. And these projects, of course, they have to submit a written project, but there would also be a presentation on each project. Almost 15 to 20 minutes time is given for each student to present, and I do it in front of the whole class, and they would also be actually participating in the discussion in the project presentation. Of course, this cannot be done during the class hours. I do it actually after the class hours. So additional project presentation schedule will be prepared, and accordingly, actually, after the class hours, actually, these things are done. So that's how the research project, along with the presentation on the cutting edge areas, I also include within the process of the teaching the method. And I believe that actually it would be really effective for the purpose of reaching out to the students in terms of teaching international trade law. I should end by saying that actually, I mean, this is not the perfect way of actually looking into it. You might have different experiences, and definitely you can tailor your own method depending on actually your requirement. That's all from my side. Thank you so much.